Robert Rauschenberg was one of the greatest American artists of the 20th century. I was engaged by the attorneys of Foley and Lardner who represented Rauschenberg's trustees. Rauschenberg created a trust to distribute his estate assets, a complex portfolio of artwork and works of art by other artists, and a securities portfolio and considerable real estate. The case arose from the fact that the trustee and the beneficiary could not agree on what constituted reasonable compensation for their services for a 4-year period of administration. Rauschenberg named 3 trustees to administer his trust, but did not specify the trustee compensation. The trustees administered and managed the Rauschenberg estate over a 4-year period for the benefit of the Robert Rauschenberg Foundation, the ultimate beneficiary. Rauschenberg died in 2008, the year the global financial crisis began. The trustees exercised great skill in their administration of the Rauschenberg Trust due to the fact that the trustees understood Rauschenberg's art and the business of art. Each of the trustees had a different experience that they brought value to the administration of the Rauschenberg Trust. First among them was the accountant who managed Rauschenberg's business and financial dealings, and the second was his life partner who created art with Rauschenberg. The third, a business partner of Mr. Rauschenberg, who was in the art catalog and publishing business. The trustees were very smart. They knew the art business. They knew how to create value in art for the 4-year term of administration beginning, and in 2012, the estate that was originally valued at $900 million distributed to the beneficiary $2.2 billion worth of art. And the trustees demonstrated great skill, judgment, and exercising their fiduciary duties that they owed to the beneficiary. The trust document, however, was silent as to what fees would be, and the trustees and the beneficiaries couldn't agree on fees. So the case went before the probate court in Lee County, Florida. I was hired by the trustees' attorneys to render an opinion as to what reasonable trustee fees would be in Florida based on a Florida Supreme Court case, West Coast Hospital versus Florida National Bank. I wrote an expert report, was deposed by opposing counsel, and testified at trial as to what constituted reasonable compensation for the trustees in this case. The trustees thought that they should be compensated somewhere between $35 and $50 million for their services. The beneficiaries thought that the trustees should be compensated on an hourly basis, and they estimated the value of that time was $350,000. So there was a wide spread between what the trustees thought was reasonable and what the beneficiaries thought was reasonable. The Lee County probate judge awarded the trustees reasonable compensation of $24.6 million. The plaintiffs appealed the lower court ruling in the 3rd District Court of Appeals in Florida, where the appeals court found for the trustees. The trustees received an additional $4 million in judgment interest after the Florida Supreme Court failed to hear the beneficiary's appeal to the higher court.